being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of Constitution, fundamental rights in 184.3. Otherwise, it can be ultra-vires of Constitution 199.
Simple. And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law?
Of course.
Oh, you see, you are saying this is a law
If
affecting
it repeals it, yes.
That this is a law affecting having such a salutary effect. It is having this, that, and the other. So someone can say, "जी पार्लियामेंट का तो पावर ही नहीं है, तो ये लॉ को रिपील कर दें." या फर्ज करें अगली पार्लियामेंट आती है, वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है, वो दैट्स गुड इनफ।
माय लॉर्ड
सकती है, आपसे पूछ रहा हूँ।
जी जी
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजूस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा। आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे। आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा। भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे। बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है, मेरी तो मुझे तकलीफ हो रही है। सुबह से 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़, आप चला लें एक महीना केस, हमें क्या फर्क पड़ता है। फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब अवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट हमारे 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें। मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तिलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है। हमें आपको परसुएट करने की कोई जरूरत नहीं, आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is questions.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल।
So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so,
Learned
and if it
Attorney
so
General.
happens,
Question.
Yes, sir.
This is not
Attorney
conjecture.
General.
This is to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
Absolutely,
General.
my lord. Absolutely.
Learned
it is
Attorney
in Parliament's competence. And if I may say so, my lord,
You
my
have,
lord,
you
I
have
have,
provided assistance. Thank you.
I have,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely.
Yes.
Yes.
Okay.
Mr. AG, to your right. Section 2 में it's provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still this power has not been given in this act. Again, there will be...
My lord, the committee determine its procedure and then it
with regards to
Who
how the
will
meetings
ass-
are to be in the
who
committee
will-
itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if two members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta registry for 1 month, for 6 months, or for 1 year. Is it possible?
My Lord,
What would we do if this situation occurs?
My Lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how the meetings were to be held and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was a first. My Lord, this is exactly what under subsection 2 the committee is to do as a first.
We will regulate through rules. They will regulate this act through rules. We
My
will
Lord,
clarify it in
Ji,
rules.
the committee will determine its procedure much the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is, an SRO or as a rule or whatever may call it, but the committee can determine its procedure. It will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my Lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to determine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who they first determined whether the matter was of public importance and relatable to enforcement of fundamental and then constitute a bench. This is this tension which my lord had also while authoring judgment, rendering judgment.
This doesn't answer the question whether the threshold of 184(3) is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?